Good evening, members. I'm Jerry Clausen, one of the clinical legal advisors at MIPS, and it's a pleasure to be with you tonight for one of our webinars. This evening is a little bit different. We're looking at the evolution of a dental complaint, and we are going to look at an actual case, follow it through, and look at the management and the implications of this case, not only to inform you, but to indicate what can go right and what can go wrong. A few little points to bring up just before we start our case presentation. First of all, submit questions using the webinar chat. We're happy to deal with these at the end of the presentation. Secondly, there will be a survey post-webinar, so please complete this if you get the chance. There'll be a certificate of attendance emailed. Your attendance will be noted on your membership, and the webinar is recorded for your later review. Finally, remember again the clinico-legal MIPS support number that you are always free to contact. So moving forward, let's have a look at our case for the evening. And we'd like to look at this particular case study, and I'd like you to follow this through with me. Our practitioner is Dr. Tan. He's an Australian graduate of Chinese origin, and he's a contractor working as a general dental practitioner in suburban Sydney. It's a busy practice, and he's got a very large percentage of his countrymen consulting him for treatment. This presentation revolves particularly around tooth 4-6. The patient is a 45-year-old female patient, Mrs. Wong, and she consults doctor with pain in the 4-6 over the previous week, a very common clinical scenario. Our practitioner evaluates the 4-6, undertakes appropriate diagnostic measures, records this information, and at the end recommends to the patient that endodontic treatment would be a reasonable approach. The patient understands the treatment options, she accepts the treatment, and treatment in fact commences. So we have informed consent and we have informed financial consent to the proposed treatment. Mrs. Wong, however, doesn't complete the treatment. She disappears off the radar for a couple of weeks and several weeks later returns. She comes back to the practice and says, "A file was fractured in my tooth." And she's seen an endodontist who she reports has removed the fractured instrument. You can see on the radiograph here, I think, a fairly clear indication of the instrument, its location within the 4-6 after the commencement of endodontic management. Not perhaps surprisingly, the patient is a little upset, and she requests at this stage that she be refunded for the costs of Dr. Tan's initial management, and also requests that the endodontist's treatment be paid for. Very soon after the discussion with Mrs. Wong, Dr. Tan moves to another practice. Unfortunately, the relationship with his previous employer sours fairly quickly, and again, this is a not uncommon scenario. Dr. Tan has an ongoing issue. The employer owes him money, wages, entitlements, and the employer presents various reasons to why he is withholding this money, and so he and Dr. Tan then have an ongoing issue as to how much is owed, how much should be withheld, are there other treatments that are going to be required. The other problem now is that Dr. Tan, having left the practice, really has difficulty in accessing the records, and again, he can't get Mrs. Wong's records to really give her request full consideration. Remember, he's seen her initially, she's come back and presented a complaint, but he has really not a lot of other information to go on at this stage. Mrs. Wong then sends in a written claim to the old practice. Understandably, this is the address that she has, so her claim is sent in there. The practice then redirects that to Dr. Tan. The claim now states that the tooth can't be salvaged and that an implant is required. So there's been an initial issue, there's been endodontic management, but now it's escalated another step. And instead of remedial treatment, we're now looking at replacement of the tooth. In a letter, of course, to Mrs. Wong, also threatens to report Dr. Tan to APRA. And this is a tactic, again, that's not uncommon. And the implication is that if you don't wish to pay the money, then I need to consider reporting you. So this tends to cast a slight threat into the equation. And Dr. Tan's previous employer, of course, contacts him and says, well, I'm going to withhold some of the monies owing to you in past commission because there's this claim against the practice and there may be other claims against the practice, and I need to be sure that I've got the funds and resources to pay if I need to. Again, common scenario, and if you put yourself in this situation, you can imagine that the pressure is starting to mount. You now have a problem, you have a written claim, you have issues with the previous employer, and you have the threat of perhaps the patient taking other action. The member is understandably pretty stressed out about this development, and it compounds the financial issues with his previous employer. He's concerned about the financial implications and potentially his future career prospects. And in the interim, an APRA letter is received stating they've received a complaint from Mrs. Wong, which they'll investigate. So at this point, Mrs. Wong has gone from threatening to complain to proceeding with a formal complaint. The issue now is that that complaint is a notification and it must be dealt with. It cannot be put aside. It has to go through due process, and the implications of that we might have a look at later on. At this stage too, the dental board have also indicated that they intend to review Dr. Tan's infection control practices as well as audit his CPD records. Why is this? It's not uncommon when there is a notification about a clinical matter for the bodies to say, we need now to look at your CPD, and also in some states or jurisdictions to also investigate your infection control. Again, put yourself in the situation and think, I started with a little clinical problem, it's become a discussion, I've now moved practices, I'm getting second-hand a written complaint, I've now got to deal with the board or APRA, and on top of the complaint, they now wish to evaluate my records, my CPD, and also my infection control practices. At this stage, at this time, our member contacts MIPS. With all of this background information, he at least makes contact, but you can perhaps understand that there's a lot that's already happened. And unfortunately, 1 month later, Dr. Tan receives a letter from Mrs. Wong's solicitor now demanding $25,000. So it's gone from a refund and the cost of remedial endodontic treatment to $7,500 to $25,000 for all past and future dental costs, and of course the costs that the solicitor incurs in then contacting Dr. Tan. So the matter has now significantly escalated in what is really a fairly short period of time, several months or less in some cases. After the dental board investigation is complete, they issue a caution and they impose registration conditions concerning education about health records and infection control practice. Why is this? It's because, again, the initial problem was an endodontic matter, but because it's been referred to the board, or in New South Wales, the Dental Council, they have decided to investigate infection control and records, and they've now cautioned Dr. Tan and imposed some conditions on him. And to complicate matters, the $25,000 demand hasn't gone away, and 6 months later, the patient's solicitors issue a district court writ, which is served on Dr. Tan at his practice. At this stage, let's just take a little break for a second, and I'd remind you I'll endeavour to respond to all the questions that are submitted, and you can submit your questions from your PC or other device at any time during the presentation. Let's have a look at some of the issues in this case. And let's have a little think together about what could or could have been perhaps done differently, or how things could or could have worked out perhaps a little better. Previous employer. This is a very common and repeated issue. Unfortunately, professional separations are not always pleasant, but it is incumbent upon you to try and manage the separation as professionally as possible. One of the key issues, again, that recurs all the time is, are you a contractor or an employee? Now, in this particular case, Dr. Tan was a contractor. In many cases, practitioners assume they're contractors because, for example, they're paid on a commission basis, but in fact, they may well be an employee. If you are an employee, this changes the equation and often means there is a situation of vicarious liability for incidents between the employer and the employee. In a contractor situation, basically, you are responsible totally for your actions. In this instance, therefore, as Dr. Tan was a contractor, he, not the practice, is the person to whom the complaint is directed. Even though Mrs. Wong sent the complaint to the practice, the complaint is with regard to Dr. Tan, not the practice in total. You've got to be clear about your entitlements, and you've got to sort these things out quickly. For example, you need to know if you have sick leave, long service leave, holiday pay, superannuation. Are you entitled to these things or not? If you're not entitled to them, then obviously you can't claim them. But if you are entitled to them, they must be sorted out quickly. And finally, apart from the financial problems, again, these sort of disputes result in professional distrust. They mean that a practice will not, in many cases, release information because they fear that you are going to steal their patients. And this means then that it harms your chances of resolving the patient complaint because you haven't got access to the relevant records and you're not really sure of the exact sequence of treatment and exactly what correspondence has gone backwards and forwards. For example, in this case, the report from the endodontist and exactly what was said. Other issues. In this instance, the previous employer is inappropriately linking the claim with the employment-related dispute. Why is this? Because it perhaps hasn't been totally clear as to whether Dr. Tan is a contractor or an employee. Perhaps, maybe it is to Dr. Tan, but maybe it isn't to his employer. So the employer is now assuming that this claim is one against the practice as well as Dr. Tan. The employer might be vicariously may have vicarious liability, and the employer is now saying, I'm going to withhold some money because this could be the first of a flood of claims. Now, in truth, Dr. Tan was a contractor, and this is an issue for Dr. Tan alone. But unless Dr. Tan takes advice and clarifies this, the situation can get extremely messy. The next point is that stress levels for everybody are increasing, particularly Dr. Tan, and of course Dr. Tan is now in many ways an unhealthy dentist, a dentist who's preoccupied about this problem, who's got to spend a lot of time thinking about this issue, and in that instance, dentists are much more likely to make mistakes. They're not really focused on what they're doing. They're focused on this past problem, and we can get into all sorts of difficult situations. So from your own point of view and your health and well-being, there are some real reasons why it's good to resolve issues with the previous employer. The other point to note at this stage is consulting countrymen. Now, for many people, it's seen as a positive because you have some degree of referral base amongst friends and acquaintances, maybe even relatives or others, and this hopefully grows your practice and you build up a bit of a reputation. It's very common in health practice, dental and medical and otherwise in Australia, but you need to be very careful because in these instances, often practitioners will attempt treatment that's against their better judgment, but it may be what the patient prefers because it could be cheaper, it could be more expeditious, and you feel an obligation to help the patient by giving them the treatment that they want. The reality is, in the cold, clear light of day, what they want may not necessarily be what they should have and what you think they should have. It compromises you when there's some relationship between the patient and yourself. So therefore, the message is treat everybody, whether they're countrymen or whether they're people you've never had any contact with, treat them all the same. Because being an associate, a countryman, a friend or similar will not be of any assistance to you in the event of a complaint, claim or investigation. Unfortunately, in our experience, in many cases where the patient has been perhaps a friend or in some way associated, what's happened is that when things go wrong, they go even more wrong than in another situation. So please don't rely on the fact that because it's somebody who perhaps as a countryman or otherwise, you probably will get away with it or they won't complain. That just is not our experience at MIPS. Let's have a look at some of the other aspects of this case now too. The written claim. The first question is, why didn't Dr. Tan contact MIPS initially? Even at the outset, we have to ask, why did Dr. Tan not notify us that there was a problem? The patient has come back and has indicated that there has been a fractured endodontic instrument. Dr. Tan may not have necessarily picked up on that, but the patient has told him that. One of the things we ask is that at this stage even, you contact MIPS. The patient may be incorrect, the patient may be providing you with the wrong information, but at least we know right from the start. At the very least, once there's something in writing, it's essential that we have contact. As you might recall in this particular case, it was a way down the track by the time Dr. Tan contacted MIPS, and at that stage, momentum had already got rolling. One of the key membership benefits is obtaining assistance and guidance when an incident occurs, and that means right from the very start, managing it and having somebody to talk to, somebody to talk about the various options. What should I do? How should I manage this? What should I say to the patient? Unfortunately, Dr. Tan hasn't had this opportunity, and it's been compounded by the fact that at the same time, he's moved practice. The concern, of course, too, is that from the patient viewpoint, the patient often feels then that he or she has been ignored and that their complaint's not taken seriously. We know in this instance that wasn't the case. There were other issues going on, but once the patient has the perception that they're getting a cold shoulder, that's why they then take matters further. And in this case, the patient went ahead and, as she threatened, reported the case to APRA. Finally, in terms of professional indemnity insurance, why do you have to have it? Well, that's why the dental board says that you should have it, so that you're able to compensate patients when appropriate and when there's a fault or when there are problems. This is normal and reasonable. So we do indicate to members that accidents occur, mistakes happen. That's why you have indemnity cover, but we can only assist you if you tell us. If we don't know, it's hard to provide assistance. Other aspects of the written claim. The tooth is now allegedly not salvageable. Allegedly not salvageable. This is because the patient has said that she now needs an implant and a crown. Do you know this or not? You don't. You don't have the information. And this needs to be determined because there's a vast difference between the cost of endodontic treatment and the cost of tooth replacement. The costs have escalated from an endodontic remedial treatment to an implant restoration. And now, of course, with solicitors involved, the costs have escalated further because of legal and other costs. Had we known about this situation earlier, we could have obtained the report from the endodontist, found out if the tooth was in fact salvageable or not, and this would have given some degree of clinical evidence as to the validity of the claim. That situation has now somewhat passed. Again, the veiled threat to implicate APRA in the initial correspondence. This can be a tactic to try and force the member to treat the matter seriously, but in some cases, as well as a tactic, the patient will pursue this. And one of the major reasons why patients do pursue this is that they get frustrated. They feel they're not being listened to, they feel their complaint's not being taken seriously, they feel there's been no response, and therefore they seek to redress what they see as a slight. They contact the regulator. And that, as we said before, sets in place a process that you cannot reverse. So again, we have members sometimes at this stage say, I've had a complaint made to APRA, they tell us about the past issues, and their question is, if I now pay the patient money, can I make this go away? And the answer is no. Once this process is going, all the money in the world will not stop the process. So it's really important, if you're going to act decisively and firmly at the outset, but unfortunately not to sit around and just wait on the matter. And in terms of refunds, again, this is something that we often have discussion about. In this particular case, in retrospect, should Dr. Tan have considered a refund? And the reality is it probably would have been a very powerful tool. The patient would at least feel that the practitioner understands and accepts her issue. The refund does not mean that you have admitted liability. It simply says that perhaps I have not provided what you wanted and I am refunding you money. You also need to be aware that a refund is something that you as an individual practitioner undertake. We often get questions, if I refund the patient the money, will MIPS pay me back that amount? And the answer is no. A refund is you deciding to refund money that you have obtained for treatment which, in your judgment, perhaps hasn't necessarily fulfilled your or the patient's expectations. It would be unreasonable if the treatment hasn't fulfilled expectations on behalf of either party, for MIPS or any other indemnity provider to then pay you for not fulfilling those requirements. So a refund is a very powerful tool. It needs to be prompt. It is not an admission of liability. It is not an admission of I've done wrong. It is not an admission of guilt. What it is saying, I understand that you're not comfortable with what I've provided for various reasons, so that you're not financially disadvantaged. I would like to refund you whatever fees, and the patient can put that refund to whatever purpose they want. A refund also, finally, is very different from funding remedial treatment. Remedial treatment is treatment to address the issue, and that's a separate matter from a refund. So in this case, if you remember, Mrs. Wong wanted, firstly, a refund because she felt that the treatment with Dr. Tan hadn't fulfilled requirements. But secondly, she also wished to have payment for remedial treatment because she now had to see a specialist. She now had to have additional, more costly and more complex treatment, which was not what she'd bargained for when she originally agreed to have endodontic treatment of tooth 4-6. From a patient viewpoint, I think you can understand that this is not an unreasonable request, and perhaps had this been managed in an appropriate way in the first place, we wouldn't have got to where we are. So as we said, finally, after some water had passed under the bridge, Dr. Tan then discusses the case with MIPS. At least now he's got somebody to discuss the case with, and sometimes dentistry can be a very lonely profession. You don't have anybody to really discuss issues with. That is what clinico-legal advisors are there for. And sometimes the discussion is pleasant, sometimes it can be unpleasant when you have to point out some errors or some problems with treatment, but at least you can have an honest discussion. In this particular case, reference had to be made to the duty of disclosure and notification requirement issues in the policy. Now, the reason for that is that if a practitioner fails to disclose a matter or discloses it late or doesn't notify the indemnity provider, this can prejudice our chances to defend you. In other words, in this instance, as you might, again to repeat it, you might understand, had we known early on, then the whole matter could have been resolved by a small refund from Dr. Tan and the cost of endodontic treatment, which is not particularly significant. You now realise that it jumped from that to $7,500 to $25,000, and in fact, as we'll find out, it jumped even more. Those costs are costs shared by all of our members to defend the matter that really should have been resolved in retrospect for a hell of a lot less. So it's a service not only to the individual, but also we need to think about the rest of our membership when we stress to you disclosure and notification requirements and their importance. And also with regard to the contact to MIPS, what would we have done in this particular case had Dr. Tan contacted us? What we would have done is acknowledge the claim and advise Mrs. Wong that the matter will be considered as a priority. Obtain the records. Prepare a statement on the sequence of events so that everybody knows exactly what went on, and then we would assist the member in drafting an appropriate reply to Mrs. Wong to acknowledge her problem, to understand the situation, to explain it, to perhaps offer to assist her with the financial aspects of management of the matter, so that we didn't actually get to the next stage whereby we then have to assist the member in addressing the dental board's concerns. If we have to, then again, that's one of the tasks of your advisor to assist you in drafting responses. And at this point, the other thing to mention is that in many cases, when a response is requested by the dental board, it is always your response. So members sometimes ask us, I've had a letter from AHPRA and I need to provide a response. Can you write the response for me? And the answer is no. The letter specifically asks for your response. And the regulatory authorities take an exceptionally dim view of a response that's not actually your own response. So it's really important to be able to assist people, but it's important that the member understands that when the member is asked to respond, it is the member that's asked to respond, not their clinico-legal advisor. These are the things, however, that we could have and should have done in this particular case had we been notified about the matter before it progressed. And, you know, again, to recap, in this case, because of the delays, Mrs. Wong's patience ran out. I've been to see you. I've discussed the matter with you, Dr. Tan. I've written about my concerns. You haven't really addressed them. I've never heard any more. I've had to go to the dental board. I've had to consult a solicitor. I've had to do all these things because you don't seem to have done anything. You don't seem to take me seriously. So her patience ran out and she lodged a notification to AHPRA, and the board will investigate her complaint. That means that Dr. Tan's got to provide all the records. So, you know, again, he's got to provide all the records. He's got to provide himself a response addressing Mrs. Wong's specific concerns and answering the board's questions. And as mentioned, the board also in this instance has decided to investigate Dr. Tan's current infection control practice by having a practice audit. Also, they requested proof of CPD over the last 3 years. And again, this can be embarrassing when a practitioner realises that perhaps he hasn't fulfilled his CPD requirements and perhaps infection control in the practice isn't quite as good as it could or should be. It just adds to the burden of what was initially a broken endodontic instrument. Unfortunately, in this case, the board investigation didn't go very well for Dr. Tan because they weren't impressed, first of all, with his dental records. The issue that you can see here now is that we started with a problem that was about endodontic treatment. It wasn't about records. It wasn't about infection control. It wasn't about CPD. The complaint was about the endodontic treatment, but because all of these other things need to be collected and need to be assessed, then in this instance, your records will be evaluated. And if the records don't meet the standards requirement, in other words, they don't have all of the information that is meant to be there. They don't list, for example, the appropriate medicaments. They don't list the materials. They don't mention where the consent was obtained to treatment. They don't mention informed financial consent. They don't mention treatment options. Then the board is within its rights to perhaps punish the practitioner because the records are inadequate. Secondly, they weren't impressed with his knowledge of infection control procedures. I'm sorry for the misspelling there. So he now has some conditions, and they also were concerned he didn't appreciate infection control was his issue and not one he could blame on the practice or the other staff. So commonly we find, not in this particular case, but commonly we find that a practitioner works part-time in a practice and is audited for infection control. The audit turns out poorly and the practitioner says, yes, but it's not my practice, I only work there. 2 days a week. So it's not me. The problem is with the practice. No, the problem is with the practitioner, because you as an individual practitioner are responsible for infection control when treating your patients. You can't sit down and say it's a practice problem. So there are a number of issues that Dr. Tan really didn't grasp with regard to infection control. And of course, these all came out during the board hearing. The end result was that, you know, Dr. Tan ended up with some conditions on his registration. So he had to undertake courses in record keeping, informed consent, infection control. He had to have a further audit of his practice until he was advised that things were satisfactory. Now, if you're thinking by doing these courses that at least you'll gain your CPD points, remember, when these courses are conditions, generally you don't get any CPD credits for them. Secondly, they're going to take up a lot of your time. And thirdly, they're going to cost you a lot of money. So when we reflect back on perhaps the very, very small cost a refund would have had, is it really worth not refunding to then have all these conditions and all of these other onerous duties? I think you know the answer. The other thing is all the registration conditions are noted in the dental practitioner register and are publicly available and will be scrutinised by everybody. If you're not sure how to do this, go to APRA, type in Register of Practitioners, type in your own name and see what comes up. And realise that everybody can see if there are any conditions or otherwise on your registration. Third point, all employers need to be advised of these conditions. Dr. Tan's case, this is perhaps an issue because he's moved practices. He has to have a discussion with his new work colleagues and advise them of those conditions. And if he seeks any other position elsewhere, any prospective employer needs to be advised of those conditions. Needs to be. You can't hope that maybe the practitioner won't see them. You are under an obligation to advise them. And if there are any breaches of your conditions or registration, then MIPS, along with other indemnity providers, can exclude you from cover. So conditions are very, very important on your registration for a number of reasons. And you remember that Dr. Tan was concerned about the financial and other implications of going to APRA. This is why. Again, you know, examples. Does it happen in real life? Well, yes, it does. And when we have a dental practitioner, like in this case, reprimanded and fined, this reprimand is on the practitioner's record until there is some reason why, and cogent reason, why it should be lifted. Now, unless the reprimand states exactly what it's for, then any prospective employer would look at this practitioner and concede that he's been reprimanded, therefore he or she must have done something wrong, therefore I'm looking at somebody else to employ. And you might notice in this particular case that, you know, there's a reprimand and a $10,000 fine. And previously, the same practitioner in December 2010 was cautioned, reprimanded, and fined $25,000 for unprofessional conduct. So board matters are serious and have serious implications for you in terms of time and cost and your future practice. And you might hope that these things will stay secret, nobody will know, and I'll fly under the radar. MIPS and other bodies have no control over the media. We have no control over media sites. We have no control over internet sites. We have no control over what is or isn't posted about you as a practitioner on various sites that perhaps some of you are aware of. But one of the things that we do know is that at the moment, for example, in certain areas, there are concerns about matters such as hygiene breaches, 1,000 people at risk, and it sounds pretty scary. And so you can understand why in this instance, because of the media hype, when Dr. Tan's notification was received, automatically it triggers an infection control order, which is one more thing that you don't need. And also in terms of media hype and advertising, the other problem is that if it's a slow news day and APRA fines against you or one of the other jurisdictions, then unfortunately this is public information. Placed on the APRA website, it can be placed on the front page of the newspaper. And perhaps you might imagine that if you were in this situation, and hopefully not smoking while you were doing root canal treatments, but if you were in this particular situation, it's probably not the best practice advertising that you could have, particularly in the current climate where dentistry is finding it a little bit difficult. So the implications, I guess, of board and APRA matters can be very significant for you as a practitioner in terms of cost, time, further implications, and also down the track in terms of your employment and other possibilities with regard to a career. And then finally, the litigation. So at this stage, you know, Dr. Tan has been through a fair bit and he's got a lot on his plate. But unfortunately, mainly because of the perception that nothing was being done because Dr. Tan hadn't contacted us to initiate any action. Not unsurprisingly, Mrs. Wong visits her local solicitors, and this then resulted in a letter of demand, as we said before, with an escalation now to $25,000. $1,000 because the solicitors are now going to say, well, any restoration is going to need replacement and repair and renewal throughout the course of a lifetime. You, as a dentist, might argue, but that would have been the case anyway. However, in this instance, the information that the solicitor has is that now the patient needs an implant. The implant and the crown are going to be more costly. The renewal and the replacement may be as frequent, if not more frequent, with ongoing recurrent costs. In a 45-year-old patient who perhaps has another 40 years to live, she might need that implant or crown replaced several times. So in a short period of time, they issue legal proceedings. And just when Dr. Wong thinks he's got over some of the issues, he's been through an infection control order, he's had to agree to having conditions on his registration, he's had to agree to do courses, he's trying to get on in his new practice and trying to get things back on the level and trying to patch up the money matters with his previous employers, this reignites his stress. Now, it also increases the resources that MIPS have to devote, which means spending member funds on lawyers. This is not something that we decline to do by any manner of means. If it has to be done, it has to be done. But let's stop and think for a minute and reflect. Should we and our members be in this situation anyway? And the answer is probably not. Could we have avoided this situation? We probably could have. But now we have no choice. There's no way to go back from here, and we have a situation which is adversarial and difficult and is going to become increasingly stressful for Dr. because he has to now do further reports. We have to get other opinions. There's a lot of stuff to be done. To complicate it in this particular case, Dr. Wong, Mrs. Wong's solicitors were not solicitors that we have often encountered. And so in such cases, solicitors are not really familiar with dental matters, And so they're going to waste a lot of time asking questions, getting reports, talking about issues that we know are irrelevant, issues that we know don't relate to the case, but because much time and money is effectively wasted. In other words, correspondence that needn't have been there, but has to be answered in the end. The result is a total expenditure of about $47,000 on a settlement and on legal costs. So let's recap. Possibly from somewhere in the order of about $2,500 to $3,000 refund and remedial treatment. Suddenly to $7,500, up to $25,000, and has now escalated to $47,000. From something that could have been resolved in a matter of weeks, it's now turned into nearly 2 years. At that time, Dr. Tan, as our member, has had to try and battle on through all of this. Understandably, he's relieved he didn't have to attend court because the matter was settled, but he had to spend a considerable amount of time out of his practice consulting with his defending solicitors, again, reviewing information, reports, records, and similar. The cost to the practitioner, as you can imagine, has actually been enormous, enormous. So in summary, I want to make a few take-home points, and just to indicate to you, out of interest with this particular case, the tooth that was apparently fractured instrument and unsalvageable actually wasn't unsalvageable at all. The tooth was restorable, but still $47,000 to settle the matter. A couple of points to make. MIPS, and again, I think other indemnity providers have seen a steady rise in dental board complaints, a steady rise. Now, certainly, in a number of instances, there are no further actions taken. If we have a look in 362 cases, no further action. So some of the complaints have been found to be without basis, which is great, but the member still has to go through providing the information, providing a report, providing a response. It is extremely time-consuming and onerous. And the best place to be is to not even get into this situation in the first instance. You'll notice too that, in a significant number of cases, cautions have been issued, and in some cases, cancellation or suspension of registration, which basically means immediately stop your career. I don't need to go into the emotional and financial implications of that, but I think it's pretty clear. Some of the key messages, again, duty of disclosure. Please, if you think something may even be worth notifying about, please notify. If you fail to disclose, it may affect entitlements. I mean, it can even result in withdrawal of cover or cancellation of membership in severe instances. But it certainly, importantly, it makes our ability to defend you much, much more difficult. In Dr. Tan's case, it prolonged a simple matter and put the practitioner under enormous burden that once matters had started to roll, we couldn't really reduce or change. So please keep MIPS informed, even if the matter doesn't turn out to be important. Secondly, these issues, cooperation and consent to treatment, they're dealt with in the information that MIPS send to you with your renewal every year. So, again, don't sit down first of all and admit liability to the patient and agree to settle the claim and agree to refund them and agree to remedial treatment and everything else. Talk to MIPS first about this so that we consent and you consent that this is the proper course of management. There's nothing worse than you having made a lot of promises to the patient in the heat of the moment about what you'll do, and then realizing that perhaps that wasn't the best thing to do, and then placing, you know, your clinico-legal advisor in a difficult situation of having to perhaps suggest to you that this really is not financially sustainable. Again, talk to MIPS first. Don't think that you can handle it yourself, because often that just ends up in frustration. And a couple of take-homes too. You know, good practitioners are not immune from complaints. Every practitioner has incidents. Every practitioner will have accidents. The key thing is the good practitioner is the person that manages those problems and doesn't ignore them. Having a notification doesn't mean you're a bad practitioner. In fact, having a notification means that you recognize what the problem was. You may reflect in this particular instance that one of the issues was that Dr. Tan, until the patient came back, didn't actually even know that he had separated an instrument. How you manage the complaint affects the outcome. In other words, active management, prompt management is completely different to a lackadaisical approach, typical of this one. And you might, you know, you might react negatively to complaints. You might feel that it implies that you're a bad practitioner. But if you get angry or rude or upset, then you can only expect the patient to do the same. And if the patient gets upset, the patient will pursue you through legal or board or other sources, which will then lead to that cascade effect that we've seen, which then leads you to a very unhappy situation. And you may sometimes have doubts as to whether you've done the right thing or not. In fact, in many cases, practitioners need to talk to somebody to say, what do you think of my sequence of treatment or my notes? And this is where it's important to be able to talk to a peer. So we want you and we encourage you to notify NIPS. There's no penalty. Again, this is a misunderstanding. Practitioners often think that if they notify us, then they will be somehow penalized or pay more in subscriptions. There is no penalty for notification. There is, however, you know, more of a penalty in some ways for not notifying or notifying late, because that really penalizes everybody in terms of case management. If you're worried about mandatory reporting, MIPS advisors are exempt from mandatory reporting. So you may tell us something in confidence and you may think that this really perhaps isn't the best in terms of treatment. Is this person going to report? And the answer is no. So that should not stop you. And again, you know, be conciliatory. Sorrow or empathy doesn't admit fault. A refund is not an admission of liability. Those are the points that I think you really need to bear in mind. So I'd like to spend a minute now just endeavouring to respond to any questions that you may have before we close off at around about 8:30. We do have a question there, and as an oral health therapist, I often see patients who have seen a dentist, are given a treatment plan for a specific issue and want my opinion on the matter. Whether it be costs, correct course of treatment, etc., what is the best way to handle this? This, again, is something that arises not infrequently. I think the key issue you have to look at here is this patient within your scope of practice? If you're commenting on patient treatment and management in a patient of an age and stage that's not within your scope of practice, then you have a problem, because your comments could be construed as, to some degree, practicing dentistry. In other words, dentistry is giving advice, giving instruction. It could be teaching, it could be clinical dentistry, but the definition of dentistry is very broad. Now, if you are going to start giving advice on a treatment plan and costs and your opinion, then you are engaging, in my opinion, in dental practice. One of the issues, of course, is that if this patient is not your patient and perhaps is outside your scope of practice, then you face some very real concerns. Personally, I think that the best idea, particularly when you have a patient who presents you with a treatment plan and wants your comments, is to respond that, you know, at this stage, you're not my patient. I haven't examined you. I haven't examined all the diagnostic information. I don't have all that information to hand. So really, it would be unreasonable for me, either positive or negative, about your treatment plan. And I think that's the best way to handle it, because if you start with criticisms, you may not necessarily know all of the information. Next question we have: should we be communicating with the patient or solicitor when and if they contact us, or should we speak to MIPS first before replying to the patient? And the answer is most definitely do not communicate with anybody until you've spoken to MIPS. I would suggest to you that if you have a communication, for example, from a solicitor, you are doing yourself, in all likelihood, an enormous disservice by getting in contact. You can say things, you can do things, you can transmit information that you will subsequently regret severely. I would say, in the case of a solicitor, always, always, always contact MIPS first. We may then give you advice about, we may help you draft a reply, we may reply on your behalf, or we may in fact appoint solicitors immediately to deal with the matter. But there are a number of options, and we need to determine what's the best option in this particular case. It's very difficult for you as an individual to do that. With regard to the patient, again, even if a communication is from the patient, before you say something or you do something or you promise something that may not, in retrospect, be the right thing to do, our advice is contact MIPS first, because at this stage, there's already been a problem. The patient wouldn't have contacted you if there wasn't a problem. Your duty of disclosure is to notify us as soon as you're aware of any problem. Next question says, shouldn't the cost be limited to refunding the cost of the failed treatment and possibly an extraction, since it isn't a responsibility to provide a replacement tooth without fee for service anyway? I think this brings up the point, you know, shouldn't you just, in this case, shouldn't Dr. Tan have said, all right, I'm sorry it didn't work out the way you wanted. I've charged you, let's just say, $385 for the initial visit. It's a pity it didn't work out, but I'll give you back the $385. Thing to do. However, put yourself in the patient's position. This patient, let's say for argument's sake, was expecting to have endodontic treatment with Dr. Tan at a cost of $1,500. The patient now has to go to a specialist practitioner. She's going to have to travel. She's got further time and everything else. She's going to have at least 1 or 2 appointments, perhaps to bypass the instrument or remove the instrument. And the fee is not going to be $1,500. It's going to be more like $3,000. This patient didn't bargain on that fee when treatment started. Who's going to pay that difference? Why should the patient have to pay for the additional treatment when an incident has occurred that was certainly not the patient's fault? So, you know, my question in responding to that is, to some degree, there is a commitment for further costs. What we would often do is we would actually take the view that the practitioner, Dr. Tan, should refund the money. He should refund his costs. But secondly, the amount that should be funded to the patient is the difference in cost between what the endodontist would charge and what the patient would have paid. The patient would have paid $1,500 for endodontic treatment in any case and had agreed to do so. The treatment cost, for argument's sake, has now doubled, so understandably the patient is out of pocket in this instance by $1,500. It is reasonable to recompense the patient for that. So that would be the way that I'd look at this sort of instance. And just to round it up, we've got one final question. Where is the evidence that the alleged broken file is Dr. Tan's? And this is a good point. And as the files are provided by the practice are the files they provide to the contractors. Also, where is the patient's responsibility given she presented with an unsalvageable tooth? Why did you settle? She had no case. Well, the first question, where's the evidence that the alleged broken file is Dr. Tan's? Well, in this particular case, it was fairly simple because the patient had only seen Dr. Tan, and in fact, that radiograph was taken as soon as the patient presented at the endodontist. She hadn't seen anybody else. So by definition, if she's only seen Dr. Tan, she goes to the endodontist and there's a broken instrument, then it's come from Dr. Tan's treatment. In some cases, of course, if patients have seen other practitioners for multiple treatments, that raises a real question. As the files are provided by the practice, are the files they provide to their contractors? Well, in fact, you know, in a lot of instances, the files might be provided by the practice. It's not the fault of the file, it's the person using it. So there's an old saying that only a fool blames his tools. And whilst we might sit down and say, well, maybe this was a metallic problem within the file or the instrument, that's great. But at the end of the day, it's the person using it where the fracture occurred. So it's your problem. You can't sit down and blame it on the instrument, unfortunately. And it then says, where's the patient's responsibility given she presented with an unsalvageable tooth? Well, in fact, as we said, it was thought to be unsalvageable, but as I showed you in the final slide, the tooth wasn't unsalvageable. In fact, it was restorable. That was something that the patient alluded to, and you know, she'd been given advice about implants. In fact, the tooth was restorable. But even if a patient, to answer this question, if a patient presents with a badly broken down tooth that's carious subgingivally, there's no supragingival tooth structure, then the real question would be, why would you embark on endodontic treatment if the tooth's unrestorable? If a practitioner embarks on endodontic treatment, one of the key diagnostic factors before you embark on endodontic treatment is the tooth restorable? If you embark on endodontic treatment for a tooth that isn't restorable, then again, the practitioner has made a serious error of judgment in proceeding with treatment. So in this instance, you know, why did we settle? Well, the reason why we had to settle the matter was because, unfortunately, in this instance, the key element was that the practitioner had, in fact, had the occurrence of a separated instrument. But the main problem was, A, he didn't inform the patient because, B, he didn't recognise that it had occurred. That, unfortunately, is very difficult to defend. So, ladies and gentlemen, I'm getting the look that I'm out of time, but we'll certainly answer any remaining questions via email in coming days. Please